Free them all.
We're saying,
Free 'em all.
Mumia Abu Jamal, Oscar Grant,
Free 'em all. And positive energy is everything to us. So again, thank you guys. Appreciate it.
Thank you so much for having us. Thank you.
Thank you.
So justice for Tyree, you guys see it here. We with the Nichols family and all the others that are out here fighting for justice for all.
Red's not supposed to be green, like faith's not supposed to be seen. The sky's not supposed to touch the ground, and a square's not supposed to be round. The moon's not supposed to touch the sun, and a two is not supposed to be a one. And the heart's not supposed to weigh a ton, and forever's not supposed to be done. Winter's not supposed to come in June, and I am not supposed to have the blues. There are so many things that are not supposed to be, babe, except you and me. There are so many things that are not supposed to be. Ooh, baby, except you and me. Night's not supposed to be long. Yeah. No one is supposed to be alone. Understanding is not supposed to be confused, and the wind is not supposed to lose. Like fire's not supposed to freeze, like joy is not supposed to grieve, like you are not supposed to leave what I said I'm not supposed to leave. He is not supposed to have your heart. Baby, we are not supposed to be apart. There are so many things that are not supposed to be said. You and me. There are so many things that are not supposed to be. Hey, baby. It seems just like no seasons changing, or this earth with no creation, or a heart with no feelings, or a sickness without a healing. Just like a frozen spring, or a bird with no wings. Just like a song out of key, it's how my life would be. Like the night skies with no stars, a lonely broken heart, no holding hands or walks in the park. That's how it would be if we were apart. There are so many things, yeah, except love. So many things that are not supposed to be. It's like having nowhere to be. No. Like having no words to breathe. No. Like having no rain for the sea. There are so many things that's not supposed to be. Not supposed to be. Except you and me, baby. Yeah, baby. Yeah. except you and me.
All right, all right, all right. Happy Monday, everybody. This is going to be a great live because we're going to read everything that Jennifer Bonjean has put together in support of her client, Robert Sylvester Kelly. First, I want to say welcome again to everybody that is in attendance to this here live. I know it's been a minute. Your girl ain't went anywhere. She's just been moving around and, going where God is leading me to be. And today he has brought me back here in the midst of the moment to report to you guys, as I have always, on Robert Sylvester Kelly. So this is some positive news, and I love to feed it to the people. So with that being said, welcome everybody to the channel. If this is your first time, welcome, welcome, welcome. If you return, and welcome back. And if you remember, thank you so very much for keeping the lights on over here for us, because it's really and very much appreciated. Okay. Now with that being said, if you guys have not hit the like button, go ahead and hit that like button. If you haven't subscribed and you like this commentary, you want to see more of this, go ahead and hit that subscribers button. Turn that post bell notification on and select all so you don't miss me, your girl, next when I come back and give you guys another drop. Now let's get into this here. What Jennifer has put together, and as you can see on the screen, I put up what she has already, her filing, okay, her filing report, and I'm going to go ahead and share my screen with you guys right now. I got my disclaimer at the bottom. I do not own the rights to any of this here audio or anything that I may use that's not mine. It's all Fair Act use. So with that being said, I'm going to go ahead and share my screen with you all right now. Boom. Okay, so there was a letter that Jennifer Bonjean did address to the courts. Okay, so I kind of wanted to read that one first. So I'm gonna go ahead and just read that one off of my phone, and then I'm gonna go ahead and start reading to you guys this here, as I always have before, and nothing's changed. A girl is back with another one. So let's get into it. Okay, let me see, where was I at on this here? Okay, gotta be this one. It has to be this one. Let's see. Okay, yep, it is. All right, so like I said, Jennifer has put together a few, not a few, but like a lengthy little something. So we're going to read all through it and give you guys the latest updates. And again, I miss you guys. Hope you guys miss me. Hopefully y'all don't stay away too long, but y'all come back, as we continue to congregate and getting this information out here for the people so we can get Kells free, because he is an innocent man of the charges that he was accused of and convicted of. Okay, so anyway, with that being said, the letter goes as follows. Grammy Award-winning artist Robert Kelly files lawsuit against the United States of America Bureau of Prisons officers and Tasha K. What? I did not even see that part. Shut the back door. Shut the back door. Natasha K is up in this lawsuit. Hold on. Where's my theatrics at? I got to get my little theatrics out here. Hold on. Here we go. Oh, yes, baby. Let me go ahead and just take this off the screen for a few seconds and let y'all see this letter that's up there, baby. She said, and Tasha K for invasion of privacy and violation of the Computer Fraud and Abuse Act, baby. She going for the whole neck, baby. And you go for the head, the body gonna fall. So she went ahead to Chicago today, November 13, 2023. The Bonjean Law Group filed a complaint on behalf of Robert Sylvester Kelly, better known as R.Kelly, in the United States District Court for the Northern District of Illinois against the United States of America and its employees, unknown BOP officers under the Federal Tort Claims Act and the Computer Fraud and Abuse Act. Yes, honey, let's go. I'm here for it. The complaint alleges the certain BOP officer conspired with each other and a YouTube blogger, Latasha K, known as Tasha K, to access and steal private and confidential information from BOP database related to Mr. Kelly, including email communications, recorded phone calls, trust account information, visitors logs, and attorney-client communications. Okay, everything that you can violate, baby. This is jail time, allegedly. The information was protected and personal, relating to Mr. Kelly's private affairs. It was disseminated to third parties and the general public, not only for pecuniary gain, but for the purpose of interfering with Mr. Kelly's defense to pending criminal charges and to harass and harm him. Mr. Kelly must now bring this lawsuit to get answers and justice because despite opening an investigation into the serious misconduct of DOJ, ultimately declined to indict the wrongdoers and allow the misconduct to continue. Ooh, baby. Now we're going to get into the fundamentals of all of this as well as the readings, y'all, okay? Let me see. Somebody say, hey. Should have not ever been done. That's a fact. Teresa Franklin, Stephanie, I see you in the building. Winnie says, no, this song is not supposed to be. Hey, boo. Yes, I understand what you was trying to say. All right, let's get into this here complaint, y'all. And let me share it up on my screen so y'all can see what I see. Okay? Boom. All right, so let me move this over a little bit because I want y'all to see everything, okay? Ooh, baby. Shout out to Jennifer Bonjean. When I tell you I didn't need to come and do no commentary on R.Kelly's case because I feel like he is in the best hands with this lawyer. There's no need to try to, you know what I'm saying, interfere or not even interfere, but just to even do commentary this far because Jennifer got this cat in the bag. I trust her work. That's why I stepped aside so she can do her diligence, her sufficient work, and baby is very effective, okay? So with that being said, I see you in the building as well, Gemini, and everybody else that's tuning in. Thank you so much for your time. You could be anywhere, but you chose to be over here with your girl hollywoodnex in the MFM building. Yes, and it's the growth in me. So let's go ahead. Let's start with the complaint. So plaintiff Robert S. Kelly by his undersigned attorney for his complaint against the United States of America, unknown BOP officer A, and they still don't even know who the officer is. Okay, they really just trying to protect their own, and the lady or her male has retired. Okay, but you got Tasha K still out here trying to drag our boy's name while she's sitting there on her little lie, dancing to his music, being sarcastic or whatever. Baby, when I tell you what's done in the dark always comes to the light, and God don't like ugly, and he not fond of pretty. So baby, just sit tight. You think Cardi B was something? Wait till you get a load up, Jennifer. She ain't fit the. No, you're gonna be able to say to her to get her to drop her lawsuit against you, boo boo. So anyway, because this is a lawsuit against Tasha K as well as the United States Bureau of Investigation. Okay, let me get into this because I'm so theatric and I love y'all and I really do miss y'all and I do miss covering this case and everything. But I'm still here and nothing's changed. Okay, let a court happen. Watch me be there now. An unknown John and Jane Doe BOP officers, collectively BOP defendants, and Latasha Kebe, also known as Tasha K, baby. I don't think Tasha K woke up on the right side to find out she got an R.Kelly lawsuit running up against that. Yes, we fit to run it up. Okay, introductions. Plaintiff sues the United States of America, unknown BOP officer, also known as Officer A, unknown John and Jane Doe, BOP officers, and Latasha Kebe for negligence. Ooh, baby, you don't want to be in this type of lawsuit. I'm sorry, Tasha. You're going down, down, down. Okay? Whew, okay, so the negligence, invasion of privacy, ooh, baby, conversion, civil conspiracy, intentional infliction of emotional distress, and willful and wanton conduct brought under the Federal Tort Claims Act, FTCA. Plaintiff also brings suit against the defendant, BOP Officer A, for violation of the Computer Fraud and Abuse Act, CFAA. Plaintiff is a high-profile prisoner of the Bureau of Prisons, BOP. He is a Grammy Award-winning recording artist and a nationally recognized celebrity, period. As with all prisoners, but particularly because of plaintiff's status, the United States of America, through the BOP, had a duty to protect plaintiff and his private and sensitive information to ensure that its employee did not exploit plaintiff for financial gain or for any other reason. Baby, I love you, Jennifer. I just want to throw that out there. I really do. The defendant, United States of America, breached its duty of care to the plaintiffs when it allowed countless BOP officers to access plaintiffs' confidential information without any legal basis to do so. The defendant, United States of America, knew the defendant, BOP Officer A, and other defendants, John and Jane, DOE, BOP officers routinely access plaintiffs' private information from its systems and divulge private information to third parties for monetary gain. Clout. Not the clout, baby. She used the word clout, girl. Shout out to Jennifer Bonjean. I need my doggone theatrics, and I need them up here front and center. And that was for the clout. Okay, she used clout, baby. Shout out to Jen. I'm telling you, she is the 2023 Johnny Cochran. Free R.Kelly. Hold on, let's get back to where we was just at. Oh, Lord, where was I at? Okay, so let me see. Okay, she said for monetary gain, clout, or simple harassment. And that's exactly what it was used for, honey. It was totally misused and shouldn't have been used. Because of the United States of America's breach, at least 60 BOP officers, not 60, y'all. Oh my God, 60 BOP officers made unauthorized access to plaintiff's sensitive, confidential, and private information maintained by the BOP on its electronic systems known as True View. Some of those BOP officers either shared and or sold that information to third parties, including members of the media and witnesses in plaintiff's criminal prosecution. Defendant unknown BOP officer A accessed plaintiff's private BOP records, True View records, including email communications, visiting lists, inmate trust account information, and recorded phone calls with the third parties and plaintiff's attorneys without authority to do so. The information was private and concerned personal matters. It was not public information. After unlawfully accessing the foregoing protected information, defendants BOP officers unlawfully downloaded the information and sold said information to defendants Kibi. Oh, baby. Not sold it to Kibi. Hold on, let's get us a horn for that one. Girl, Tasha K was over there buying information as it is alleged in this here complaint, y'all. The defendant, Kibi, a popular YouTube blogger with over 1 million subscribers who published the private information publicly without identifying how she received it. Defendant Kibi relied her massive following to harass the plaintiff with the use of the stolen information and created chaos in plaintiff's personal life, even using the information to influence witness in plaintiff's Eastern District of New York criminal prosecution. You better say it, honey. You better say it. On information and belief, the stolen information was shared with and used by prosecutors from the United States Attorney's Office as a tool to influence witnesses against the plaintiff. The sale of the information yielded profits that neither defendant BOP officers A nor defendants Kibi were entitled to and which belonged to the plaintiff, if anyone. The Department of Justice officers of the Inspector General investigation initiated a secret investigation into the unauthorized access of plaintiff sensitive information. The department did not inform plaintiff of the investigation and never has. Wow, y'all. Even still to the day, never has. Plaintiff later learned that the investigation resulted in the issuance of a search warrant for a BOP computer used by defendant's BOP officer A and forensic analysis of the computer. According to an affidavit of Special Agent Matt Lukes of the Department of Justice, later obtained by plaintiff's attorney, probable cause existed to believe that the defendant BOP officers A committed a criminal violation of 18 U.S.C. 10. Oh, baby, Tasha K, you going to jail. Oh, Lord. 1030A2B, that is unauthorized access of a computer to obtain information. See, they was messing with the federals when they did this, Tasha K. You allegedly is going down. From the Federal Bureau of Prisons, no charges were brought against the defendant BOP officer A, and the government has refused to reveal any details about the investigation, including the identity of officer A. In short, there has been a cover-up. Oh, call it like you said, Jen. Call it like you said. She's saying it for me. I used to say this stuff to y'all all the time, but I'm happy it's coming from a creditable source, which is Jennifer Bonjean. In short, there has been a cover-up of the rampant BOP misconduct that is ongoing. Even after this so-called investigation and lawful access to plaintiff's TrueView records continue, even after being put on notice of repeated violations of the CFAA by BOP employees, the United States failed to protect plaintiff and breached its duty to protect his private and sensitive information. For example, the defendant unknown John or Jane, DOE, BOP officers made an unauthorized access to plaintiff's TrueView's record and obtained information about plaintiff's trust account funds in August of 2022. Woo, baby, that's as recent as August of 2022. That's just last year. That unknown defendant BOP officers divulged the information to a journalist for the Washington Post who published the personal information. The publication not only placed plaintiff in a false light, falsely suggested he was concealed his resources. The monies were actually generous gifts from his loyal fan base, but resulted in the DOJ confiscating nearly all of plaintiff's monies held in his prison trust account, over $25,000. Jennifer, add me in that lawsuit too, and the people who donated to R.Kelly. I'm just saying, we want to make sure that money still goes to Mr. Kelly, okay? Plaintiff was forced to pay for legal services to litigate the unjustified taking of the money, an issue that is now pending before the Second Circuit Court of Appeals. Plaintiffs maintains that the DOJ had no authority to confiscate those funds, which would have not occurred in any event if the information was not leaked to the public by a defendant unknown John or Jane Doe BOP officers. The defendant BOP officers committed the torts of invasion of privacy, conversion, civil conspiracy, intentional inflictions of emotional distress, and willful and wanton misconduct. The defendant BOP officers, including the defendant BOP Officer A, also committed violations of the Computer Fraud and Abuse Act, CFAA. Plaintiffs suffered a multitude of loss and damages as a result of the defendant United States of America's negligence and the torts committed by defendants BOP officers. A, and other unknown John and Jane Doe's BOP officers, included but not limited to legal fees and emotional and psychological distress. Oh, yes, he is definitely having all of that, honey. Yes, and add a whole bunch more to it. Separately, losses in excess of $5,000 accrued as a result of the CFAA violations committed by the defendant BOP Officer A. The misconducts resulted in an internal investigation by the BOP and investigation by the DOJ, OIG, and both the seizure and examination of a BOP computer hard drive. Jurisdiction and venue, guys. Let's get into it. Okay. This court has subject matters jurisdiction over this matter pursuant 28 U.S.C. 1331, in that this action arises under the laws of the United States of America and is premised on the acts and omissions of the defendants acting under color of federal law. This court further has subject matters jurisdiction pursuant to 18 U.S.C. 1030G, which permits an individual who suffers damage by reason of a violation of the CFAA to bring a private cause of action. The action is timely filed where it is brought within 2 years of the discovery of the damage. This court further has subject matter jurisdiction over this matter pursuant to 28 U.S.C. 1346B, where plaintiff sues the defendant, the United States of America, for money damages for injury caused by the negligent and wrongful acts and employees of the government while acting within the course and scope of their officer or employment under the circumstances where the defendant is a private person would be liable to the plaintiff. Jurisdiction founded upon federal law is proper in that this action is premised on federal causes of actions under the Federal Tort Claims Act, FTCA, pursuant to 28 U.S.C. 2671. Pursuant to FTCA, plaintiff filed a notice of claim on November 14, 2022, and served his claim to the appropriate federal agency for administrative settlement under the FTCA, requesting $1 million or more. Woo! Get it, Kels. By letter dated June 15, 23, plaintiff claim was denied in writing by the North Central Regional Office of the Federal Bureau of Prisons, and such denial was sent by certified mail to the Plaintiff's Counsel, claim TRT NCR 2023-02361. This action is timely pursuant to 28 U.S.C. 2401B in that it was presented to appropriate federal agency within 2 years of accrual, and this action was filed within 6 months of the receipt of the certified letter sent by the federal agency denying the claim. This court also enjoys supplemental jurisdiction if necessary under 28 U.S.C. 1367 in connection with claims against defendant Kebe, who, if not acting as a contractor for the federal government, is liable, baby. Do you hear? Liable right there. For claims that are so related to the claims in the action within such original jurisdiction that they form part of the same case or controversy. Venue is proper in this district pursuant to 28 U.S.C. 1391B and 1391C as defendant do business in this judicial district, and a substantial part of the events giving rise to the claim occurred in this judicial district. Now the parties, y'all. Plaintiff Robert Sylvester Kelly is a 56-year-old Chicago native. He is indisputably the king of R&B. You better say it again. Let's give her a horn for that one. Because she's speaking facts. Plaintiff Robert Sylvester Kelly is a 56-year-old Chicago native. He is indisputably the king of R&B. He is currently an inmate incarcerated in the Butner Federal Correctional Center in Butner, North Carolina. At times relevant to this complaint, plaintiff was an inmate at the Metropolitan Correctional Center in Chicago, Illinois. The defendant, United States of America, is subject to suit for injury caused by the negligent and wrongful acts and omissions of employees of the government while acting within the course and scope of their office and employment under the circumstances where the defendant, if a private person, would be liable to the plaintiff pursuant to the FTCA. At all times, materials to this action, unknown BOP officer known as Officer A was a federal BOP disciplinary hearing officer and law enforcement officials employed by the BOP with access to the BOP's True Views system. Although plaintiffs does not know the true identity of Officer A, the BOP does. She is the officer identified in the search warrant application and affidavit of Agent Matt Lukes. That was provided to plaintiffs by the U.S. Attorney's Office in June 2022 during plaintiff's prosecution in the Northern District, Illinois. At all times, material to this action, unknown John and Jane Doe, BOP officers, were BOP officers assigned to the Chicago MCC and perhaps other BOP institutions with access to the BOP's TrueView system. Although plaintiffs does not know the identities of the 60 different BOP officers who made unauthorized access to his confidential information, the BOP does. Plaintiff sues each and every BOP officer who accessed his confidential information without authority and whose identities are available from the BOP. At all times, material to this action, Tasha K is a resident of Lawrenceville, Georgia. K is a popular YouTube host with a YouTube channel called Unwind with Tasha K. She broadcasts content to 1.3 million subscribers across the country, including in Chicago, Illinois. Now let's get into the factual. Plaintiff was arrested in the United States District Court, Northern District of Illinois, NDIL, on July 11, 2019, in connection with a 13-count indictment, United States versus Kelly, 19 CR 567. Shortly thereafter, plaintiff was separately indicted in the United States District Court for the Eastern District of New York, EDNY, in connection with RICO charges brought under the case 19 CR 286. After his arrest, plaintiff was detained in the Metropolitan Correctional Center in Chicago, MCC, for nearly 2 years until he was transferred to the Metropolitan Detention Center in Brooklyn, MDC, to face trial in the Eastern District of New York case in and around June 21, 2021. During this period of time, plaintiff was pretrial detainee. While detained in the MCC in and around January 2020, plaintiff's longtime girlfriend, Jane Doe, began behaving in a hostile and accusatory fashion toward the plaintiff without explanation. Jane Doe was furious with plaintiff and unexpectedly began causing stress and conflict in the relationship. These arguments related to money issues, romantic issues, and other highly personal issues. Plaintiff later learned that in and around that time, Jane Doe abruptly began cooperating with the government, which led to her becoming the government's star witness against him in the Eastern District of New York prosecution, okay? In and around that time, the defendant, Kibi, a popular YouTube blogger, began publishing information to her, 1.1 subscribers, and other viewers, private information about the plaintiff to which she should not have had access. The defendant, Kibi, did not reveal how she received said confidential information. Was she about to talk now? Y'all, that mockingbird. Just by way of example, on November the 7th, 2019, the defendant, Kibi, posted a video on YouTube titled, R.Kelly Can't Control His Girlfriends While Behind Bars. Kibi told her viewers that the information came from a phone tap somewhere. Kibi disclosed information that appeared to come from plaintiff's prison's calls with Jane Doe and his girlfriend, J.S. Kibi appeared to disclose private and personal information and plaintiff romantic relationship. The defendant, Kibi, proceeded to divulge to her YouTube viewers the contents of plaintiff's prison's phone calls with his girlfriends and others, email communications about his private life and legal issues with numerous people, visitors logs, and trust account information on numerous other occasions. Again, without disclosing from where she received the information or how she received the information, plaintiff was incarcerated and had no ability to watch Kibi's YouTube channel to learn the specific information that was being said by defendant Kibi. At one point, plaintiff visited with Jane Doe and was shocked and confused when Jane Doe accused him of making certain statements concerning his personal life that were only shared with plaintiff's lawyers at that time. Jane Doe refused to divulge how she received the information, but claimed that she was privy to plaintiff's conversations with his attorneys. Plaintiff had no idea how certain private information was making its way into the public domain. In early 2020, the BOP went on a complete lockdown as a result of the pandemic for a year. Attorney visits were conducted entirely by phone call, and eventually Zoom visits and face-to-face visits did not resume until late 2022. It is unclear how many of plaintiff's attorney-client communications were shared with third parties by defendant BOP Officer A, or why those communications were being recorded at all. In June of 2021, plaintiff was transferred to the MDC in Brooklyn, New York, to stand trial in his RICO prosecution. His federal RICO trial commenced on August the 9th, 2021. A jury returned a verdict against him on September 27, 2021. Plaintiff's current counsel filed an appearance in the Eastern District of New York case in October 2021 for the purpose of handling post-trial motions and the eventual appeal. Her role expanded after plaintiff's original trial lawyers withdrew from the Eastern District of New York case by January 2022. Undersigned counsel filed an appearance in the Northern District case on February 18, 2022, and with her legal team began preparing for plaintiff's Northern District trial scheduled to commence in August. After counsel legal team received information about the unauthorized and illegal taking, sellings of plaintiff's private specific information, counsel sought discovery from the government. On June 14, 2022, attorneys for the government produced to plaintiffs' counsel an application and affidavit for a search warrant under the case caption in the matter of the search of the HP desktop computer bearing serial number 2UA8480JG51506. The materials did not include plaintiff's name or any BOP officer's name. Neither plaintiff nor his counsel had access to the anonymously filed search warrant application and affidavit until it was produced by the government on June 14, 2022. The government refused to provide any additional information despite plaintiff's request. According to the materials produced on June 2022, Special Agent of the Department of Justice of the Inspector General Matt Locks, Agent Locks, executed an affidavit in support of a search warrant for a computer located in the Northern District of Illinois related to a violation of 18 U.S.C. 1030A2 and B, that is unauthorized access of a computer by obtaining information from the Federal Bureau of Prisons. Agent Locks arrived that the OIG received information from the BOP. The unknown BOP officer A was suspected of accessing sensitive law enforcement information maintained on the BOP's electronic system and providing that sensitive information to an individual who then released the information on social media platforms. Specifically, the warden of the MCC in Chicago reported an allegation of staff misconduct to the BOP Office of Internal Affairs when MCC staff became aware of the unknown BOP officers, including defendant BOP Officer A, had stolen plaintiff-sensitive information from the BOP's electronic system, known as the TrueView system, without authority to do so. The BOP's TrueView system is an application that contains information on inmates, including inmates' email, inmates' telephone calls, inmate visitation lists, and inmates' funds. The TrueView system contains information from various other applications and systems existing on BOP's network infrastructure. The information available on TrueViews, including information from BOP application. TruePhone, the inmate telephone system, which houses recording of inmate telephone calls. Agent Locke's investigation showed that unknown BOP Officer A had not only made unauthorized access to plaintiff's TrueView records, but stole information from the records, downloaded information, and then divulged that information to YouTube bloggers Defendant Kebe. Defendant Kebe then revealed that stolen and sensitive information to the general public and the specific third parties, including Jane Doe. On information and belief, Defendant Kebe and other unknown individuals bought the information from defendant unknown BOP Officer A. The information constituted inter-ally private conversation between plaintiff and Jane Doe and his girlfriend J.S. The communication related to personal and private relationships matters. Financial issues and even attorney-client matters. Although plaintiffs did not know at the time how Jane Doe obtained the information, when plaintiff had the opportunity to learn of the contents of Agent Locke's affidavit, he deduced that the information had been stolen by the unknown defendant, BOP officer, sold to Defendant Kebe, and then exploited for a profit when Defendant Kebe divulged in the public and to other third parties, including Jane Doe. Defendant Kebe recently admitted on one of her broadcasts that she did obtain the information from defendant BOP Officer A and not only disseminated the information publicly, but provided additional information to Jane Doe and others, including Jane Doe's family members, for the purposes of interfering with plaintiff's criminal prosecution. The release of this private information on the internet created a feeding frenzy about plaintiff's personal life, his relationship with Jane Doe and JS, and resulted in the termination of certain important relationships that plaintiff enjoyed with other individuals. The unauthorized release of the information led to a physical fight between Jane Doe and JS that made national news. The theft of thousands of dollars and chaos and discord in plaintiff's life. Furthermore, because information about plaintiff's visitation list and trust fund balances became public news, plaintiff was no longer able to enjoy certain important and supportive relationships with people. Defendant Kebe released the names of certain individuals who supported plaintiff, publicly shamed those people, calling them enablers, and interfered with those relationships. Understandably, plaintiff's associates did not wish to be harassed or have their employment put in jeopardy because of the illegal conduct of defendants BOP Officer A and Kebe. Plaintiffs suffered significant emotional distress as a result of the release of this information and further worried about what other private information was in the hands of third parties. Both before and even after plaintiff learned about Agent Locke's affidavit, plaintiff spent sleepless nights, distressed and confused how his private conversation had been leaked to the public. Who was responsible for it and who was responsible for it? Importantly, plaintiff suffered emotional and distress because he did not feel at liberty to freely speak with his attorneys. Plaintiffs learned that his attorney-client communications were not only recorded, but information from those calls were released by Jane Doe and presumably others. Plaintiff did not and still does not know the extent to which his private information has been divulged publicly. Agent Locke's investigation revealed that from the period of July 15, 2019 through January 8th, R.Kelly's birthday, 2020, 60 defendant BOP officers had accessed plaintiff's TrueView records, including defendants unknown BOP officers. Indeed, defendant unknown BOP officers engaged in unauthorized access to plaintiff's TrueView records a whopping 153 times. To this day, hold on, y'all, I gotta say that again. To this day, plaintiff still does not know the extent of his damages, injuries, and loss, as the government has refused to disclose to the plaintiff information about what the investigation revealed and the precise nature of the stolen information. Agent Locke's investigation showed that private and sensitive information from plaintiff's TrueView records became part of the defendant's Kebe's content in her Instagram posts on January 12, 2020, and videos on November 7, 2019, November 8, 2019, and December 22, 2019. The information included private information about plaintiff literacy, his medical issues, private information about his romantic relationship. At no point did defendant Kebe reveal the identity of the person who provided her with the information. Indeed, the identity of the individual who revealed the information to defendant Kebe remains a mystery until this day. Agent Locke's investigation further showed the unknown BOP officer, Officer A, plaintiff's records from the TrueView system, scanned those records, and then emailed that scan to third parties, including defendant's Kebe. The content of those materials were published on defendant Kebe's YouTube channel. Defendant unknown BOP Officer A was not the only BOP officer who engaged in unauthorized access of plaintiff's private records. Indeed, Agent Locke reported that at least 60, y'all hear this? 60 other BOP officers had made unauthorized access to plaintiff's confidential TrueView records during a 6-month period. The BOP knows the precise identity of those officers, as do the officers who engaged in this unauthorized conduct. Even after the BOP discovered these rampant violations of the CFAA, they allowed the behavior to continue. The plaintiff learned that in and around August the 4th, 2022, an unknown BOP officer made an unauthorized access to his TrueView records and obtained information about plaintiff's inmates' funds. That unknown BOP officers leaked information about the balance of funds in his trust account to a journalist from the Washington Post, who published an article with the stolen information provided by the defendant unknown BOP officer. Immediately after the journalist divulged the information, the funds in plaintiff's trust account were confiscated by the United States Attorney's Office. Plaintiff was forced to hire counsel to litigate whether the U.S. Attorney's Office had the right to confiscate the fines where no restitution judgment had been entered against plaintiff, and he was not in arrears for paying any court-ordered fees or costs. Plaintiff promptly filed a notice of claim on November 14, 2022, and served his claim to the appropriate federal agency for administrative settlement under the FTCA, requesting $1 million or more. By letter dated June 15, 2023, the plaintiff's complaint was denied in writing by the Northern Central Regional Office of the Federal Bureau of Prisons, and such denial was sent by certified mail to the plaintiff's counsel, claim TRT NCR 2023-02361. This complaint comes less than 6 months after plaintiff's claims was denied. Now let's get into the cause of action. First, cause of action of the negligence, you guys, against the defendant, United States of America, okay? So, the plaintiffs repeat and realleges all of the paragraphs in this complaint as if fully set forth herein. The Federal Bureau of Prisons is a United States federal law enforcement agency within the U.S. Department of Justice that operates U.S. federal prisons and is responsible for the care, custody, and control of federal prisoners. The defendant, United States of America, owed a duty of care to the plaintiff who was incarcerated in the BOP. The defendant stood in such a relationship with plaintiff that the law imposed on the defendant an obligation of reasonable conduct for the benefits of the plaintiff, including protecting his confidential and sensitive information, including attorney-client communications, and to protect him from exploitation from its employee that could result in harassment and prejudice to his pending criminal cases. Specifically, and consistent with its own policies and regulations, defendant United States had a duty to ensure that plaintiff's confidential and sensitive information was accessible to only those BOP officers with a legitimate basis to review it. The BOP had a duty to protect the sensitive information from disclosure and theft, and to protect both plaintiffs from exploitation by BOP personnel. As set out in detail above, the defendant United States breached that duty when it permitted countless BOP officers, including unknown BOP officer, Officer A, unlimited access to the information, the ability to download it, and the ability to sell and divulge it, which unknown BOP Officer A did when she provided private information to defendant Kebe. The breach further caused the publication of confidential information obtained from plaintiff's trust account, which was stolen and shared with other media sources. Even after the BOP became aware that its employees were repeatedly accessing plaintiff's private and sensitive information without legal authority, it took no steps to prevent the misconduct. The breach was the direct and proximate cause of plaintiff's injuries, namely the release and dissemination of his private and confidential information to third parties and the public at large. The public dissemination of private communication, including attorney-client communications, interfered with plaintiff's relationships, led to harassment from the public, and caused serious prejudice to plaintiff's defense. The defendant, United States, knew or should have known that by allowing unfettered access to plaintiff's private information, BOP officers would access, steal, and exploit that information for financial gain or for clout. Okay, shout out for her for the clout word. Plaintiff suffered emotional and psychological distress from this breach, where his sensitive information was used to harass him, interfere with his personal relationship, and was used to interfere with the defense of his pending cases. Plaintiffs also suffered monetary damages, including but not limited to legal fees. Second cause of action, invasion of privacy against unknown defendant BOP officer. also known as Officer A, and other John and Jane Doe BOP officers whose identities have been concealed by the DOJ and BOP, and defendant Kibi. Let's get into this invasion of privacy. Plaintiff repeats and realleges all of the paragraphs in this complaint as it fully set forth herein. Defendant unknown BOP Officer A and the unknown BOP officers committed repeated unlawful and unauthorized intrusions into plaintiff's confidential and sensitive information as defined by the BOP. The intrusions is highly offensive and objectionable to a reasonable person, although certain privacy rights are forfeited when an individual is arrested and incarcerated. Plaintiff, who was not yet convicted, still maintained a recognized privacy interest in his communications, visitors list information, trust account information, and his attorney-client communications per the BOP express policies. This information set out in the detailed fashion above was defined as private and confidential by the BOP itself. The information was not for public consumption. Plaintiff had every right to trust that his messages with third parties, his phone calls with friends, family, and his lawyers would remain under the care and control of the BOP and not published to the media for financial gain or in connection with interfering with his rights to obtain a fair trial. As reflected above, the communications were private in nature. They related to personal and family problems, romantic interests, health problems, literacy issues, and issues related to the defense of his pending criminal cases. Clearly, plaintiff's conversations with his girlfriend J.S. were personal and private, as were plaintiff's conversations with his attorneys. Simply, but the information was not public information. The intrusion caused plaintiff anguish and suffering. The release of his private communications were broadcast to the public. The communication led to the loss of important and close relationships, conflict and chaos in plaintiff's life, harassment and extreme paranoia. Plaintiff was isolated and fearful to communicate with his attorneys or other third parties where he knew that his private information and conversation could and did get released to the general public for mass exploitation. The violation even led to plaintiffs having to seek psychological care in the MCC for psychological stress caused by the intrusion of privacy. Now let's get into the third cause of action: conversion against unknown defendant BOP officer, also known as Officer A, and other John and Jane Doe BOP officer whose identities have been concealed by the DOJ and BOP, and defendant Kibi. Let's go. Plaintiff repeats and realleges all of the paragraphs in the complaint as if fully set forth herein. Defendant unknown BOP Officer A made repeated unauthorized access to plaintiff's private and sensitive information. She downloaded plaintiff's private information, including email communications, recorded phone calls, visiting lists, and trust account information, and sold the information to defendant Kibi. So they know that she bought this stuff, so it's definitely illegal. Baby, you better watch out. They come through your back door. Defendant Kibi used the stolen and private information for financial gain by divulging it to millions of people via her YouTube platform. The information belonged to plaintiff and was maintained by the BOP on behalf of the plaintiffs, but for BOP policies assuring the plaintiff that the information would not be disseminated publicly, plaintiff would never have made certain communication. Defendant BOP officers took unauthorized control of the property and shared it with third parties, causing plaintiffs serious damages as detailed above. Fourth cause of action: civil conspiracy against unknown defendant BOP officer, also known as Officer A, and other John and Jane Doe BOP officers whose identities have been concealed by the DOJ and BOP, and defendant Kibi. Plaintiff repeats and realleges all of the paragraphs in this complaint as if fully set forth herein. As described more fully in the preceding paragraphs, the individual defendant BOP officers acting in concert with one another and other co-conspirators, known and unknown, conspired to accomplish an unlawful purpose by unlawful means. In addition, These co-conspirators agreed among themselves to protect one another from liability for depriving plaintiff of his rights. Do I hear Rico coming, y'all? Sounds like a Rico to me. She said, conspirators, baby. In furtherance of the conspiracy, the defendant BOP officers, including Officer A, committed overt acts and were otherwise willing participants in joint activity. Ooh, baby, they work together. That's a Rico to me. The violations of Illinois' law described in this complaint, including defendant's invasion of privacy and violations of federal computer fraud and abuse, were accomplished by defendant's conspiracy. The misconduct described in this count was objectively unreasonably, was undertaken intentionally and in total disregard of plaintiff rights. As a direct and proximate result of this misconduct, plaintiff suffered injuries, including but not limited to emotional distress, and is more fully alleged above. Fifth cause of action, intentional infliction of emotional distress against unknown defendant BOP officer, also known as Officer A, and other John and Jane Doe BOP officers whose identities have been concealed by the DOJ and the BOP and defendant Kibi. So that means Tasha knows where she got that stuff from, y'all. Plaintiff repeats and realleges all of the paragraphs in this complaint as I fully set forth herein. The acts and conduct of the individual defendants as set forth above were extreme and outrageous. The defendant intended to cause or were in reckless disregard of the probability that their conduct would cause severe emotional distress to the plaintiff. The individual defendant's actions and conduct directly and proximately caused severe emotional distress to plaintiff and thereby constituted intentional infliction of emotional distress. The misconduct described in this count was undertaken with willfulness, and reckless indifferences to plaintiff's rights. As a direct and proximate result of the defendant's wrongful acts, plaintiff suffered injuries, including but not limited to emotional distress, and is more fully aligned above. Sixth cause of action, intentional inflictions of emotional distress against unknown defendant BOP officers, also known as Officer A, and other John and Jane Doe BOP officers whose identities have been concealed by the DOJ and BOP and defendant Kibi. The plaintiff repeats and realleges the paragraphs in this complaint as if fully set forth herein. At all times relevant to this complaint, the defendant had a duty to refrain from willful and wanton conduct. Notwithstanding that duty, these defendants acted willfully and wantonly through a course of conduct that showed an utter indifferences to or conscious disregard of plaintiff rights. This was intentionally done on purpose with malice, aforethought. As a direct and proximate result of the defendant's wrongful acts, plaintiff suffered injuries, including but not limited to emotional distress, and is more fully alleged above. The seventh cause of action, violation of the Computer Fraud and Abuse Act against unknown defendant BOP Officer A. Plaintiff repeats and realleges all of the paragraphs in this complaint as if fully set forth herein. As detailed above, defendant BOP officers A intentionally accessed information from an agency of the United States of America, namely the BOP, without authorization, and divulged and sold the protected information to third parties. Specifically, defendant Officer A accessed the TrueView records of plaintiff A, BOP prisoner, without authorization, or he exceeded authorized access in order to obtain TrueView's records with consistent inter-ally of email communications, recorded phone calls, visitors list, trust account information, and attorney-client communication. The information accessed and retained by defendant Officer A from a BOP computer has been determined by the United States of America to be protected against unauthorized disclosure. Defendant BOP officer transmitted that protected information to a third party who publicly disseminated it. A search warrant application filed by Special Agent Locke shows that probable cause exists to believe that the defendant A committed the offenses of 18 U.S.C. 1030 A2 and B. Losses in excess of $5,000 accrued as a result of the CFAA violation committed by defendant BOP officer A, the misconduct in an internal investigation by the BOP, an investigation by the DOJ OIG, and both the seizure and examination of a BOP computer hard drive. Wherefore, plaintiff R.Kelly praised this court enter judgment in his favor and against defendant United States of America, unknown BOP officer A, unknown John and Jane Doe BOP officers, and Tasha K awarding compensatory damages, costs, and attorney fees against all defendants and punitive damages against each of the individual defendants in the individual capacities for such further and additional relief as this court may deem appropriate and just. Jury is demanded in this case. Ooh, baby. And that will conclude that part of the reading. And I will take any questions you guys may have. Okay. And let me get into the chat. I see y'all up in there, so thank y'all. All right, well, that is the conclusion of that there reading and the complaint that has been set forth for the officer BOPA as well as Tasha K, y'all. So Tasha K is definitely being sued and held responsible for her actions that she has, intertwined herself with this here case against Mr. Kelly, and it's just given a lot right there. So you guys can go back and watch the playback on this here. Let me see if y'all saying anything in a comment that I need to respond to, because if not, that is most likely going to be my time, because I got some more commentary that I want to bring to the people. But yeah, let me see what y'all saying in the comment section. I can't stand Tasha K. Unfollow because she's just too messy. Watch Tasha K gonna fool her followers and put a spin on it. It's one thing to get new tea, but she's hateful and messy as hell, and I can't stand her because of that. She needs to be in jail. I said she needs to go to jail. Wow. He's going to use lifetime next. Free R.Kelly till it's backwards, period. She's a horrible person. Hey, Mr. Jesse, I see you in the building. Violated all of his civil rights. Absolutely. Tammy, hey, Tammy, I see you in the building. I wouldn't be surprised if he came up unalive before they go down. He needs protection while in there at this point. I agree. He definitely needs protection. I see you in the building, Miss Diane. McLean says government psyops. Let's see. Good. Jennifer, get them, girl. You're on a great motion. They need to be ashamed of themselves. They need to be sued. Absolutely. Let me see. Derek said she going down. Do it till her legs shaking. Ooh, not the legs shaking. Yeah, baby. So yes, y'all. Wow, this was great. I'm gonna be honest. This is really good news to me in my ears today. I definitely want to come and report on this one for sure. Let's see. So Cardi B case is nothing compared to this case. Miss Wine no have bigger fish to fry. Because God don't like ugly, as y'all know, and He's most certainly not fond of pretty. And yeah. So let me see. Just make sure I cross my T's before I get up out of here and dot my little I's. Where is I supposed to be at? Okay. All right. Well, that's my time, you guys. I do appreciate y'all for hanging in there with this reading of this here motion, that this complaint and this lawsuit that Jennifer Bonjean has filed against these individuals who was responsible for, all the unlawful things that they did to get a conviction on Mr. Kelly. It was wrong and it should have never happened. If they can't, present factual information to get him the right way, doing it illegal is not the way. So I'm seeing a turnaround coming. I'm continuously keeping my faith in all of this, and I will be back to give you guys more updates when they become available. And I see you guys on the next one. That's my time. Oh, if y'all haven't hit that like button on your way in, please do so on your way out. And if you're not subscribed to this growing channel, go ahead and hit that subscribers button, turn that post bell notification on, and select all. Don't miss me, your girl, next when I come back and give you guys another drop. And that's my time. Pieces. Free R.Kelly.
Red's not supposed to be green, like fake's not supposed to be seen. The sky's not supposed to touch the ground, and a square's not supposed to be round. The moon's not supposed to touch the sun, and a two is not supposed to be a one. And the heart's not supposed to weigh a ton, and forever's not supposed to be done. Winter's not supposed to come in June, and I am not supposed to have the blues. There are so many things that are not supposed to be, babe, except you and me. There are so many things that are not supposed to be, ooh, babe, yeah, except you and me. Night's not supposed to be long, yeah. No one is supposed to be alone. Understanding is not supposed to be confused. And the wind is not supposed to lose. Like fire's not supposed to freeze. Like joy is not supposed to grieve. Like you are not supposed to leave. What I said I'm not supposed to mean. He is not supposed to have your heart. Baby, we are not supposed to be apart. There are so many things that are not supposed to be said. You and me. There are so many things that are not supposed to be. Hey, baby. It seems just like no seasons changing, or this earth with no creation, or a heart with no feelings, or a sickness without a healing, just like a frozen spring, or a bird with no wings, just like a song out of key. That's how my life would be, like the night skies with no stars, a lonely broken heart, no holding hands or walks in the park. That's how it would be if we wanna fun. There are so many things, yeah, except love. So many things that are not supposed to be. It's like having nowhere to be. No, no. Like having no words to breathe. No, no. Like having no rain for the sea. There are so many things that's not supposed to be. Not supposed to be. Except you and me, baby. Yeah, yeah, babe, yeah, except you and me.
Pieces.